All right, breaking news for you today. We have that big ruling on the Trump immunity claim. The Supreme Court of the United States, the majority opinion saying that the President of the United States, not just Donald Trump, but the President of the United States has limited immunity when it comes to official acts. But what this means for the timeline and the prospect of this case actually moving forward in Washington, D.C., let's find out more about that and welcome in Ron Chapman now, federal defense attorney. Ron, great to have you with us.
Thank you so much.
I mean, I guess kind of cutting to the chase here, the bottom line is that this decision today, aside from the technicalities involved, it really makes it that much more difficult for Judge Chapman to move forward with the cases pending in Washington, D.C.
Well, absolutely. I mean, I could have predicted this outcome. In fact, I always thought it was going to be 6-3 all along. But the one thing I didn't predict is that the court was going to go a bit further and actually analyze some of these acts to determine whether or not they would constitute official acts. We have 5 acts that are alleged in the indictment, essentially, and the court seems to have broken those down. Obviously, that's not something that Justice Barrett concurred with, but I think that creates a much more difficult job for Jack Smith and Judge Chapman to analyze this and to try to work their way around this ruling to allow this indictment to survive. It doesn't look like there's very much left of these 5 acts alleged against Donald Trump.
I'm just a simple caveman, not an attorney. I use this joke all the time. You may remember the unfrozen caveman lawyer thing. I'm not even a lawyer. I'm just a caveman. But reading through this decision today, there's little nuggets in there that I think are interesting, including one of the footnotes here that it says the court also notes in a footnote in this decision, and this is coming to us from SCOTUS blog here, that the district, if necessary, should consider whether 2 of the charges brought by Jack Smith against Trump in Washington involving obstruction of an official proceeding can go forward in light of this ruling last week in the Fisher v. United States case. That was the one that basically determined a lot of these January 6 defendants were overcharged. Talk to us about that aspect of this case and what do you think that footnote means here in this decision?
Absolutely, it's vital, and that speaks to the timing of these decisions. We had Fisher come out last week. Obviously, they waited to unleash this decision because Fisher has massive implications. And let's just lay this out. Over 300 January 6 defendants were charged with something that the Supreme Court has now declared unconstitutional. Let's make that 301 because one of them is Donald Trump himself. Mm-hmm. As a result of that unconstitutional finding related to obstruction of justice, there's going to have to be a reversal of convictions. And given that Donald Trump's case is still ongoing, the district judge has to determine whether or not that obstruction charge can survive. How will she do that? Well, she's going to look to see if there was any attempt, alleged in the indictment, to destroy documents which caused obstruction. Or falsely create documents. The fake electors are going to be cited as those documents, the purported fake elector certificates. But here's the interesting thing about that. In this decision, we look at it and we see, and I've just read it very quickly, we see that the Supreme Court doesn't seem to think that there's as much strength behind this allegation related to creating fake slates of electors, because as discussed during oral argument, they were only to be used if the states changed their votes and if Donald Trump actually won those states. So I think those charges are going to go away, and I think this is a tremendous victory for Donald Trump.
And one of the things I think that's really interesting here, Ron, is if you take a step back, and when we were talking at first, when these charges and the indictments first started coming down, or maybe even before that, you talked to constitutional experts, and the reason why it has always been so difficult to bring cases against a former president in the past is because it would lower the bar. And what we're seeing here in this case is more doubt raised about these types of prosecutions against the president. The bar was not high enough to actually move forward, I think, in a lot of these cases. And I think for lay people out there, that has an effect to, again, not getting too bogged down in the specific wording of these decisions, but long-term what it means. And I think, I'm reminded of that quote from Richard Nixon when he said, sometimes when the president does something, it's not against the law because he's the president effectively. That's because the president is, and I think Donald Trump's attorneys argue this very effectively, the president finds himself, whether it's Donald Trump or anyone else, in a very unique set of circumstances sometimes, and they have to be able to act not worried about their political opponents coming after them for recriminations.
That's exactly right, and I agree with that 100%. The line here is whether or not an act was official or unofficial. There's no immunity, everybody agrees, for unofficial acts. All of these crazy examples that we heard from the DC circuit about shooting somebody in the middle of the street, it doesn't apply here at all. Official acts are those things that we've asked our president to do or that he's decided to do, and in many cases may be very difficult things. Trump's team started off an oral argument in this case talking about some of the difficult decisions President Obama had to make and
Right.
President Bush had to make, and how different the system might be if we saw retroactive prosecutions against those individuals. We end up with lawfare, we end up with a disrupted system, and that's what the Supreme Court stands for today, is that we need to move past that in order to keep our country moving forward, because that's more important than prosecution of a single person.
Yeah, and I always thought that, Trump's defenders should have spoken more about this, because the way you phrase it, I'm about to phrase this in somewhat of a hyperbolic manner, but when you're talking about Barack Obama and the decisions he had to make, you can think about Anwar al-Awlaki, who was an American citizen, who was a terrorist. He lived in Yemen. By all accounts, a bad dude, but Barack Obama ordered a drone strike to kill Anwar al-Awlaki, and in the process, he also killed his son, who was an American citizen, a 16-year-old teenager. So if you wanted to phrase it as such, Barack Obama orders the extrajudicial killing of a 16-year-old. That sounds terrible. That's something that you would think you could be prosecuted for, but in that case, I don't think they should be able to prosecute Barack Obama, even though I think that act is wrong. There are obviously constitutional questions there, but that's for the law, that's for the courts to decide that type of thing. But if you get into that arena, the president's going to be completely handcuffed.
That's exactly right. And I think the Office of Legal Counsel, the office that sort of advises the president, indicated that strike was going to be okay. But one of the problems with prosecution retrospectively is that we end up diving into those questions in a public forum, or we end up diving into them in a secret prosecution, neither of which are going to be sustainable for this country, because we have more important duties to keep these things secure. We look at President Obama and Guantanamo Bay and the Supreme Court decisions that came out related to the lack of habeas corpus. There are things that we could look at for every president of the United States that may be prosecution worthy, and certainly more prosecution worthy than some of the stuff that is alleged against Donald Trump. And I think that this puts an end to all of that, and hopefully the Supreme Court has allowed this nation to settle a bit.
All right, next I want to kind of dive into the dissent here from Sonia Sotomayor, which is very emotional. I didn't listen to the real-time recitation of her dissent here, but this is one of the things she says. Today's ruling reshapes the institution of the presidency and makes a mockery of the principle that no man is above the law. The decision, quote, gives former President Trump all the immunity he asked for and more, because our Constitution does not shield a former president from answering for criminal and treasonous acts. I dissent. And she also said, one thing that was pointed out here is that she did not include the kind of perfunctory, with all due respect, I dissent. She wrote something to the effect of, with great fear for our nation moving forward, I dissent. Very salty from Sonia Sotomayor. And she goes on to say here, immune period, immune period, immune period, immune period. 4 times she mentions immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Sonia Sotomayor writes in her dissent, because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. So that's Sonia Sotomayor. What's your reaction to that?
Well, with all due respect to a justice of the Supreme Court, I dissent from that. Here's why. You can't start off with the idea that these were evil acts or that they were even conducted. What we have here is an indictment against a former president of the United States. And in reviewing that dissent, it looks very clear to me that this justice's mind is already made up with respect to those facts. And I see some parroting of some of the talking points, which is surprising coming from a Supreme Court justice, but some of the talking points of the prosecution in this case. No, instead, we need to look, just like Justice Roberts told us, not at the impact, not at the supposed evil that was done. We need to look at the office, and we need to look at the Constitution, and we need to look specifically at the allegations. When we look at those allegations and we determine whether they're official or unofficial, we are not condoning the evil, unofficial acts of an individual. But instead, this allows a president to engage in those official acts in the way that he sees fit. Sure, perhaps some bad conduct may be excused. That's why we have Congress. That's why we have impeachment. And that's why we have immunity in this case, so that those processes can play out.
And elections, too, for that matter. And, I also think it's interesting that she chose to use Donald Trump's name in this dissent. She could have referred to the president, the office of the presidency, or any number one of those things. Now, if she comes out this hard against a specific person, if there is any more business before the court that involves Donald Trump specifically, I don't know how Sotomayor doesn't recuse herself. I mean, I don't think she would, but this opinion is so biased against Donald Trump, I don't see how she could be unbiased in future court decisions that might involve him.
It's certainly concerning. I mean, one of the issues is that she's having some trouble with legitimacy right now, right? If her side is not going to get what they want out of some of these decisions, it seems like there's going to be a bit of a revolt. And so I see that she's trying to please them somewhat by coming out with this salacious conduct. We've honestly seen Justice Thomas do this a little bit in criminal cases, where there may be a decision for a criminal defendant, but he dissents or he doesn't agree, and he lays out all of the heinous acts that the criminal is alleged to have done. We see Justice Sotomayor taking a page out of that book in order to make this conduct look very egregious. Along the lines of what you're saying, my big problem with this is that we have now a Supreme Court justice talking about these acts in a way that they've been conducted, which could speak to a potential jury that is sat in Washington, D.C., and inform them of her view. Yeah, recusal is necessary, but also going to be a lot harder to pick a jury. I don't think that day will come, but she should have been mindful of that, to be honest.
Yeah, I know. It seems like kind of an amateurish move. And again, I'm not a lawyer here, but you wouldn't expect her to make it this personal against Donald Trump. And especially when Democrats are so often raising the alarm about the politicization of the Supreme Court. This is one of the most political statements you're ever going to see coming from a federal judge. Ron, great to have you with us. Really enjoyed this, and we'll do it again soon. Ron Chapman for us today. Thank you.
Thank you so much. It was a pleasure.